Viewers, welcome to Graphic Online TV. Today we have with us lawyer Gary Nimako, the Director of Legal Affairs of the New Patriotic Party and a private legal practitioner. We are here to talk about issues mainly concerning the Asin North case. Counsel.
Yes, sir.
Good afternoon, sir.
Good afternoon. How are you?
Thank you, sir. Well, welcome to Graphic Online TV.
You're welcome to my private law firm.
And the Daily Graphic. Counsel, first of all, you were very instrumental in this case going to court. What necessitated the NPP to first pursue this case in court?
Well, I think this case primarily was a family affair. A family affair simply means that it was a case that was being fought by the NDC themselves. It didn't start with MPP. It started with NDC themselves. They were fighting their own internal battles. You know, before I think they started their internal primaries, a member of their party petitioned the party that this gentleman, Mr. Quayson, does not hold only Ghanaian citizenship, and that he was holding on to the Canadian citizenship. Now, when the petition went there, they didn't, address the petition. So there was rancor and rift in their camp. They made him go through the primaries, and he won the primaries. Post the primaries, then they petitioned the Electoral Commission, I believe, and I think nothing happened again. And then they came to us. You understand that this is a problem they have in their camp, So we studied the documents and realized that look, it is clear that a gentleman, as at the time he was even engaged in the primaries, he was still holding on to the Canadian citizenship.
So, sorry. So you mean it's even in their camp that this thing started?
The case started from NDC camp. It didn't start from MPP. It is the NDC internal matter.
During their primaries.
During their primaries.
Okay.
They were complaining that the gentleman has a dual citizen. We didn't know about that. They were complaining. They themselves were complaining. So when we saw the document, we realized that no, the gentleman indeed has a Canadian passport and has not relinquished him as at the time of their primaries. They went ahead and filed him on October 5, 2020, when EC opened nominations for filing of candidates. All that time, he still does not have the renunciation certificate. He didn't have it. All the way to the time when I think somewhere November 2020, he had the certificate of renunciation. At that time, they had fired him already. So the point is very simple. The law already had been made in this country through Espadez and Natajima Rawlings case that if you want to contest political party elections as an MP, at the time when you are filing your nominations, you must make sure that Article 94 criteria conditions, which are set by the Constitution, you meet all the requirements. Registered voter, citizen of Ghana, 21 years and above. You don't owe allegiance to any other country. You have paid your taxes or made a arrangement to pay your taxes. You are not a convicted felon, i.e. less than 10 years. All the criteria that is there, the eligibility criteria, the qualification criteria, you must meet them at the time when EC opens nominations, not before. So, for instance, in Zenator case, I know my view already. I have formed the view that in the NDC Constitution, they have put there that you must meet the criteria when they are doing their primaries, same as MPP. So when you come for the primaries, you have your voter ID card, you are not a convicted felon, everything is there. But then they allow her to contest the primaries in Kotekole. At the Supreme Court, the court said no. All that we are doing at the political party level is all expression of intention. So which, if a person is filing with the EC, and at that time that person does not meet Article 94, then he can be disqualified. Aside that, you can't do anything more. So that is exactly what the court has applied now. So for me, it's not. I don't see anything that anybody should cry here and cry about it. That the gentleman he put his passport in an envelope and filled certificate of renunciation form, whatever, filled forms and mailed it. And so at that time we can say that he has renounced. No, that's not how renunciation is done. Because see, there are clear guidelines on renunciation. It can be refused. It can be the fact that you have applied doesn't mean you'll be given or you'll be granted. It can be refused. For instance, if you are somebody who is below 18 years, it will not be granted. If you don't pay the required fees, it will not be granted. If you fill the form wrongly, it will not be granted. If you have espionage cases with the country, somebody who has state secrets, and maybe they realize that you want to go and sell the secret to a third country or second country, whatever it is, they will not grant you for you to go. Or they've arrested you on espionage charges and you want to go and say now you want to renounce citizenship. They will not agree. If you owe taxes, it's an obligation, you must pay.
So Council, it was not a formality that if you put in the application, the renunciation.
It is not automatic. It is not. That's what I'm saying. Those who are arguing that the fact that he has put in the application to renounce, it means he has renounced. Then what is the point about certificate of renunciation? What is the point? Because see, before you get to that stage, let's understand something. When you hear somebody called a naturalized citizen, it simply means that the person is not a born citizen of the country. Somebody who is called a naturalized citizen, it means you're not born there. It is a process that you went through, legal process that you went through. So for example, you went to the country with a visit visa, or let's say with student visa, or say with working visa, or say with marriage visa. How about you went into the country legally? And then with time, you graduated and now got your resident permit, what they call in America green card. Or in the UK, they call it indefinite leave to remain. Okay? It's indefinite status. At that stage, you can stop there. Okay. At that stage, you are still holding on to your Ghanaian passport. Okay. And then they've just affixed or stamped the indefinite visa in the passport. So you are still a Ghanaian citizen.
But you can remain in a country.
And you are remaining there without any limits. But you're not a citizen of that country. You are still a Ghanaian citizen. Now you want to elevate yourself into a status of a citizen because maybe you have lived there long enough and you qualify. So you apply to naturalize. When you apply to naturalize, then if the application is granted, then you go to what you call naturalization ceremony. It's a ceremony that you go through. You go, it's about 15-minute ceremony. You go and they go and swear allegiance in the UK to the Queen of England, Queen Elizabeth II. Now is the King, Charles III. In Canada, the same allegiance. You go and swear to King Charles III. Now that you are going to bear this here. I mean, all this. Let me read the thing for you to hear. You see, then you put your name there. So now it will be Gyakye Quayson, swear, or the bracket affair, that I will be faithful to His Majesty the King, then to be the Queen, okay? The King of Canada, his heirs, successors, and that I will be faithful and observe the laws of Canada and fulfill my duties as a Canadian citizen. There is allegiance you are swearing. This is what you are swearing to. If it's in Ghana, you swear allegiance to the Republic of Ghana. So when you do this, then you are giving what you call certificate of naturalization. Okay. After that, you can now go and apply for passport, a Canadian passport. So when you apply for Canadian passport, you add your certificate of naturalization, and then you now apply with your details. Then they give you what? A Canadian passport. That is the procedure. So, I mean, I don't get a point.
So the information.
And there is no way that you can get a Canadian passport as a person who was not born there, or get American passport as a person who was not born there, or get a Ghanaian passport if you're not born in Ghana. if you don't swear the oath of allegiance. There's no way. The ceremony you must attend, and you must go and swear the oath of allegiance to the country.
So, Council, the information that Mr. Quayson, the statement that he said that Canada does not allow one to swear any allegiance.
I've read to you the oath of allegiance. And if you don't care, I can repeat it. I've read to you.
Okay.
You see, this is what you swear. When you swear this and you insert your name, after that, you are given certificate of naturalization. You add a certificate to your forms to apply for a Canadian passport. In the same vein, if you want to renounce, you go to a procedure. Now, if for instance you are in Ghana and you fill the form for the renunciation, pay the required fees, you take it to the Canadian embassy in Ghana.
Yeah.
Okay? And they will take it to Canada.
Yeah.
Now, because of the COVID, they stopped interviews.
Yes. So.
Okay? But now COVID is gone. So interview is part of the requirement. Where they must find out from you whether you have the mental state of mind to know what you are doing. Because sometimes the person may be mentally, may not be right and does not even understand what he is doing. They want to be sure whether indeed you really want to renounce. You see, and all the criteria and the renunciation you qualify. Then if they are sure and everything is fine, then they can say, well, you are not somebody of any interest to the country, you don't have any obligation with the country, you don't owe any tax to the country, you are not somebody who is carrying state secrets and everything. So we have now agreed, and then we will grant you certificate of renunciation. On the day that it's given to you, it takes effect a day after. So if it's given to you today, tomorrow, 20th, it takes effect. So how come that you know very well that you have not gotten a certificate of renunciation, yet you come to Ghana, you go and pick form of electoral commission, and you fill the form that you do not owe allegiance to any other country other than Ghana. Okay? And you do statutory declaration, and then the commissioner for oath affix his seal on the form for you. What do you think you were doing to yourself? And then that form is filled on 5th of October 2020. And that form is taken to the electoral commission. Meanwhile, the certificate of renunciation is dated November 2020. So by the calculation, clearly anybody will know that at the time you were doing all these things, you knew very well that you had no certificate of renunciation.
The full reasons of the court are not yet out, but the court gave some consequential orders. Said that the filing, the election itself, the swearing in were all unconstitutional based on Article 94(2)(a). Also ordered Parliament to expunge the name of Mr. Gyakye Quayson from the list of parliamentary. But there's this school of thought out there, one that was, I think, being professed by MP for Boko Central, that the Supreme Court could have been more liberal with its interpretation. That why couldn't the courts have expanded it to say that, okay, instead of saying that it should take effect when you were filing, it should rather take effect when you were being sworn in? Because in the end,
I have not heard him say that anyway. But if indeed Mama Yarega said that, Honorable said that, I disagree with him. And it's very simple. Election is a process. It's not an event. To go to election is a process. It starts with filing of nomination forms. In fact, even before nomination forms are filed, people start campaigning already to show their interest. They put their names out there. They want to go here. You know what is happening now? People are throwing their weight all over. They want to go for elections. They are mentioning their name. Yes. Then, once you are interested, you want to go to an election. Now you now come in and you file formally with the Electoral Commission. The filing is part of the election process. After filing, or when you are filing, you add all your documentation to it. After filing, you go and do your campaign. Notice of pool is issued by the Electoral Commission. It's published out there. You know who and who are contesting. Voter register is given to the candidates to look at it. But because the national elections, a voter register is exhibited publicly to go and check your name. Maybe it's political party elections, they'll give the readers to all the delegates to go and look at the thing. But because the national, you have to publicly exhibit the voter register. And then on the day the election is coming, we will now go and queue and go and vote. So how then do you delink the processes of the nomination period and all those things and only limited to election period? How do you do that? As if you get up in the morning from your room, then you go that same day, nobody finds nomination, nothing happens, you just go and go and vote. The court cannot do that. And you see, in law, the foundation of everything has to be strong. Okay. You can't put something on nothing. If you are building a house, the foundation is there, you start putting something on it. Okay? The foundation is weak, everything will crash down. As I'm saying, the foundation of this whole thing was weak. So Mr. Quayson's election, in fact, the filing, which is the beginning of the filing itself, he ought not to have filed in the first place. He ought not to have filed in the first place. So when the filing is found to be wrong, everything that builds on it is wrong.
Also, I mean, as you said,
you can't put something on nothing. Yes.
When these things started, the foundation became weak, as you put it, during the primaries. Now, during the Janato case, you took up the position that all these things, before you even contest, you should make sure that you've met all the criteria under Article 94.
Yeah. You
are the director of legal affairs of the NPP. Is this something that you have told the NPP, or is this something that the NPP?
Oh, NPP,
so that it doesn't become a challenge to you, because now you are also going into elections.
Yes, immediately after the Janato case. You know, NPP, what we do normally is that they vet you. It's a vetting committee that vets to make sure that you meet 94, all the requirements. What we did post Janato case, then my senior brother, Honorable John Board, was General Secretary. What we did was that we set up what we call a verification committee. And that committee invited all the aspirants, 275 MPs, and those who were contesting, all of them. And the committee vetted everybody and the form again. So when you come, there's a checklist. You check. To our citizen, yes, no. When the civil said no, have you heard the name citizen of any country before? When say yes, it's a red flag. So you must give us proof of renunciation before we will file it with the electoral commission. Taxes, whatever, any convict, but whatever, we checked everything. So this problem can never happen in NPP. It's not possible. Everything is verified by the verification committee, despite the fact that you have gone through the earlier vetting in the constituency. You have been able to win your primaries and whatever. If any of them were found, and even now we are still going to do it again, if you are found that for some reason, one way or the other, you are disqualified at 94, despite the fact that you have won your primaries, the committee will recommend to NEC to disqualify you.
So Council, since this is a constitutional provision, Article 94, will you suggest that maybe it should be put inside a political party law?
It is there. It is there already. 94 is in NDC constitution. It is in MPP constitution. It is there already. It is there already. That is the reason why we took issue with the NATO matter, because it was in the constitution of NDC that all the criteria under 94 should be met by all the candidates at the time of their internal primaries. And they didn't do it. Even though the lady didn't have voter ID card, they allowed her to cross that bridge. That is the reason why Honorable Nyamashite took issue with it and said that he's going to court. So all that we were saying was that it is a high court matter. It's not a Supreme Court matter. Because there was not about constitutional interpretation as 21 years of age, voter register, a Ghanaian citizen and a registered voter. You see, we to the view that it's a high court matter. But then, they elevated it and said, at what point in time does this constitutional provision take effect? Is it at their political party primaries or at the time of filing with the electoral commission? Hence the Supreme Court action. And the Supreme Court made it clear that at the time when the Electoral Commission opens nomination, 1945, and they invite people to come and file, that time you must make sure you are qualified. At that time, if you don't qualify, they shouldn't file you. You understand the thing? So I think that NDC should have taken guidance from the Zanato case, and then should have said that, well, we think that this gentleman is taking guidance from this particular case has not received certificate of renunciation, and therefore we will not file you. You see? But they decided to file the person, despite the fact that they knew. And the gentleman also knew that he hasn't gotten the certificate. He knew about it. But then lucky for him, just before the elections, he had it. But the law didn't say that you must do it before the elections. You must do it at the time of filing. At the time of filing. Very, very crucial. 45 combined with 94. At the time of filing. But not at the time of elections.
Exactly. But Council, this case, the decision that was given by the Supreme Court recently, was it really necessary for us to have gotten there? Because as you said, there's another case. I mean, there was a constitutional interpretation. The impression I had was that interpretation took care of all the criteria under 94. The High Courts also used the same. Why should there be another constitutional case?
Well, I agree with you. We shouldn't have gotten there. But don't forget that this is about politics. And this is about elections. This is our political party. This is about a political party's candidate that you want to more or less unseat in Parliament. And look at the nature of Parliament now. 137. Okay, plus 1, making 8. Yeah. And clearly, if one person is out of the scene, it creates some level of discomfort for the other political party. So, yes, I agree with you that we should have gotten there. But I'm not sure that the political party will just sit down and keep quiet and they will not challenge the matter. So I commend them. They fought very hard. They fought for High Court. They fought at the appeal court. They didn't challenge. I think the appeal was struck out. They fought at the Supreme Court. And how many years? I think it's over 2 years.
Yes, since 2020.
Over 2 years. The injunction was taken in Cape Coast High Court. They came to Parliament. Look at what happened in Parliament. They came to fight in Parliament, resisting that the man should be allowed to vote. When the gentleman knew, he was in court.
Exactly.
He was in court. In fact, earlier on, he was trying to evade service. He was trying to evade service of the rate. Yes. And then later, he realized that no, there's nothing he can do. So he took the service. Injunction was granted. He still came to Parliament. The clerk of Parliament was served. And that thing, I think, was an aberration to the highest point. That service has been effected upon you. And you come to Parliament, the chamber, you don't just announce that yes, all members have been served with an injunction from Cape Coast High Court by a bailiff of the court, blah, 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 blah. Because I was sitting there when he was served. I made sure he was served. I made sure that he was served in his office by a bailiff of a court in Accra. So I thought that he would just announce that yes, he has been served. So the judgment should excuse them from the chamber. But he didn't do that and came to the courtroom, to the Parliament. The chamber kept quiet until Honorable Fenyomarki and the rest started asking questions, and then look at the justice. I don't think it was right. If you had made the announcement, we would have avoided all the chaotic scene that happened in Parliament. I put the blame squarely on the doorstep of the clerk of Parliament then, Sarah.
So now you are talking about politics. That this is politics. There's a by-election looming.
Yes.
Very soon. In fact, it's imminent because the Supreme Court has given a decision.
Yes.
Not to prejudice a case in court, but there's a case.
Which case are you talking about?
There's a perjury case against Mr. Quayson. Currently, a criminal case against Mr. Quayson. But there's also a decision of the court that his name should be expunged. And now per the chronology of events, he now is no longer a citizen of Canada.
That is correct.
So what it means is that as of now, he meets the criteria under 94(2)A.
That is correct.
The NDC is saying that they are still going to bring Mr. Quayson as the parliamentary candidate.
You see,
shouldn't the MPP be scared?
Oh no. I don't think so. You see, I am not the director for legal affairs for NDC, so I do not purport to proffer them any advice. I can only advise my people in the MPP. But you see, with the vexed matters at stake and having a criminal matter pending on your head in respect of these issues, and I mean falsification of documents and perjury and all these things hanging on your neck. If I were the Director for Legal Affairs of the NDC, I will advise the General Secretary that in view of the pending matters in court, let's wait for the court to decide on these matters before that person is presented again as a candidate for future elections. Because we don't know how the case will turn up, whether left or right. You see? But it's politics. They may decide, or as I said, they said they have decided to go and present the person as a candidate again, but the matter is pending in court. The court will decide one way or the other. If the court decides that, well, what he has done is correct, nothing is wrong about that, then he walks home free. If the court decides otherwise, what happens? It means that you have problem. So, if I were the General Secretary or the lawyer over there, I would have told them that I think with these matters, the uncertainty hanging on the neck of the gentleman, let us wait for the court to decide. If the court decides on the criminal matter, then we can present this person on our ticket for future elections. That's what I want to give them. I will not risk putting the person up when the case is pending on his neck. I will not do that.